जय हिंद, नमस्कार साथियों आपके अपने यूट्यूब चैनल एसएम डिफेंस एकेडमी में आप सभी का हार्दिक स्वागत है। इस वीडियो में बात करने वाला हूँ मैं दिल्ली पुलिस कांस्टेबल रीमेडिकल कोर्ट केस के बारे में। इस वीडियो में लाइव हेयरिंग आपको दिखाने वाला हूँ। आप सभी को पता है कि हाई कोर्ट गया हुआ है मामला ईसा मैडम राजेश चौहान के। कुछ मामले कल भी थे हेयरिंग उनकी, लेकिन उनका आज दिया हुआ था, लेकिन आज उन दोनों का था। तो इसमें लाइव मैं वीडियो में दिखाने वाला हूँ, बिल्कुल भी स्किप मत करना। आपको इस बहस से पता चल जाएगा, इस वीडियो का आप एकदम ध्यान से सुना, आपको पता चल जाएगा कि जज का क्या कुछ मूड है, जज क्या कहना चाहता है, जज की क्या इच्छा है, रीमेडिकल देने की है कि नहीं है। ये वीडियो देखने के बाद मैं आपको ये रोज़ जो सवाल उठते हैं ना आपके मन के अंदर, वो सारे ख़त्म हो जाएंगे कि मेरा कब रीमेडिकल होने वाला है सर, कब केट के ऑर्डर से होगा कि नहीं होगा। बस आप वीडियो काफ़ी लंबा है, मैं समझ रहा हूँ, लेकिन ये सब चीज़ रिकॉर्ड करके आपको दिखाने ज़रूरी है। आपने खाली सुना ही था हाई कोर्ट के अंदर मामला है, लेकिन आपको पता नहीं है कैसी बहस की जाती है वहाँ पर। इतने दिन यही सुना था कि वकीलों के बीच में बहस होती है, लेकिन आज जज और वकील के बीच में बहस थी। और क्या मैं ईसा मैडम को बहुत बहुत धन्यवाद देना चाहता हूँ। आप मतलब दिल खुश हो जाएगा कि इतने लंबे, ये देखिए सच्चाई है, वो सच्चाई है, कोई बात नहीं है, इसकी सच्चाई है। लेकिन ईसा मैडम ने क्या बहस किया यार, आप सुनना एक बार खाली। इस वीडियो को बिल्कुल भी स्किप मत करना, काफ़ी लंबा है, लेकिन धैर्य बना के पूरे इस बहस को सुनना, आपका दिल खुश हो जाएगा। बाकी मैं फाइनल परिणाम बताऊंगा वीडियो के एंड के अंदर, तो आप वो भी सुन लेना। इस वीडियो को कंटिन्यू बना के रखा। चलिए आपका बिना टाइम वेस्ट किए मैं वीडियो की शुरुआत करता हूँ।
When was the medical board decision in this item number 61?
Your Lordship, 61?
Yes.
Yes, Your Lordships. I'm so grateful for this. Lordship, just give me one more. A gap of 7 days, Your Lordships. 21st was the DME and 27th was the RME. And Your Lordships, in fact, 61 by pointed out, Your Lordships, I had requested to take
First of all, this instruction you have shown doesn't say that there must be 1 month between DME and RME.
Lordships, even if there is no, Your Lordships, assuming there is no 1 month.
All it says is that if there is a DME, the finding of that the DME is adverse, the finding of the DME should be communicated to the officer.
Yes, sir.
The officer has a right of 1 month of appeal. Within that month, if the officer submits an appeal and if the authority is satisfied,
yes,
then the authority can have an RME.
Yes,
here it's a case where within 1 week the authority has had an RME. And the DME and RME have both concurrently found you suffering from the same problem.
Your Lordships, I am so grateful. In fact, Your Lordships have put that. Your Lordships, assuming, alright, I assume that 1 month period which is there in Vijinder Singh and in the instructions is not applicable in this case, Lordships. Even if it is not. However, the procedure, Your Lordships, they cannot deviate unless a policy decision has been taken. Lordships, just bear with me for a moment. The procedure was that in case the DME rejects on any medical condition, they have to be given an opportunity to produce at least 2 certificates from any government hospital. Lordships, here because they were not given that chance, no show cause, nothing, immediately medical done. In fact, in this case 7 days. There are cases where overnight they are told appear for remedical tomorrow, and they will admit to that because they have placed in the writ petition MHA notification.
What is the purpose of giving them an opportunity to produce these 2 medical certificates? Please tell me.
Your Lordships, there could be human error.
What is the consequence? They produce 2 medical certificates.
Yes, Your Lordships.
Now, what can be the consequence of that 2 medical certificates?
Lordship.
It is not as though no instruction says that you will ignore your DME and you will rely on an outside medical certificate. No instruction says that.
Lordships, instructions don't say that.
Right? So the highest that can happen if you produce 2 medical certificates is that they may say, all right, this gives some rise of doubt, we will have a review medical board.
Yes, Your Lordship.
Here they have had a review medical board even without this 2 medical certificates. And the review medical board has concurrently found you suffering from the same problem.
Lordship, I am so grateful.
So if we apply the prejudice principle,
yes,
how does it make a difference? That you have, even if you had got this opportunity of producing 2 medical, we could have understood if the instruction said that if you produce 2 medical certificates, they can go by that. They can't. If they are satisfied that the matter needs a review, they have to constitute an RME.
Yes.
They have constituted an RME. The RME has given the same report. There is the question of having 1 more medical examination.
Lordships, I am so grateful, Your Lordships. In fact, this is fallen from Your Lordships. Your Lordships have said that if they are satisfied, they can constitute an RME. Lordships, today, let them say anywhere, even in the, Lordships, just bear with me for a moment, in their writ petition, even if there is a whisper to the fact what was the reason for their satisfaction for an RME. Tonight, a candidate is declared unfit by the DME. Tomorrow, they are sending for RME just like that, pushing about 10,000 candidates go for an RME. Lordships, no reason, no ground. Your Lordships, in cases like cubitus valgus, where the degree has to be examined. There can be a human error by the DME, Your Lordships. It may be 20 instead of 22, and maybe I will come in within the guidelines of MHA or Delhi Police for that matter.
Your argument is accepted, that means they should not have had an RME. You'll go by the DME.
Lordships, all I'm
You see, on the one hand, they are giving you a second option, a second check. You are asking, why did they do an RME?
Lordships, all I'm saying is
They have given you an option, an extra second look at it.
yes, Lordships.
So if you are having a problem with why they had the RME, we'll say okay, we'll say that then the RME can be ignored. Go by the DME.
Lordships, all I'm saying is, Lordships, in certain cases, in fact, the DME and RME reports are also differing. I will come to those cases also, and this is the consequence of, Your Lordships, having the medical in a hurried manner. Instead of giving them an opportunity, giving them a show cause. Your Lordships, and there is a reason, because there are categories of temporary unfitness and unfitness. There is a reason that 1 month has been provided. It is not for no reason that 1 month is written in the guidelines, and they are relying on it. Lordships, for example, in 61 itself.
Sir, before you proceed further,
Yes, Your Lordships.
can you show us a single order in this where the tribunal has proceeded on this ground? All these arguments that you are raising, show us even one order
Your Lordships,
where the tribunal has gone on this basis that there was 20 days, 15 days, they didn't follow 1 month. The tribunal reproduces Tikaram Meena, which has, in fact, it is astonishing. The tribunal reproduces Tikaram Meena, which has 3 judgments of this court, saying you will not have a fresh medical examination after review medical board. They don't distinguish those judgments, and they say we will follow this, have a review medical board. Each of these orders has to go on non-application of mine.
Lordships, I'll just answer that. Your Lordships, just give me an opportunity. I'll answer that. Your Lordships are right in saying that, that's
Now you are trying to justify the tribunal order by finding out some way of getting
No, Your Lordships,
making out a case.
Your Lordships asked me Vijender Singh for this matter. Your Lordships, that is why I showed the guidelines, to show that these guidelines were also showed in the tribunal, and the tribunal was also of the opinion that these guidelines.
Where is that opinion? This is cyclo-styled orders. Cyclo-style, just cut, copy, paste orders, where the same paras are reproduced without any application of mind. A finding is given that these are all identical. Refer it to a third medical board. What is this? What kind of order is this? Where has the tribunal said that you didn't give them the mandatory period of 1 month, you didn't give them this, you didn't give them that? Where is all this?
Your Lordships, but the tribunal has gone on temporary, unfit and unfit, and there is a reason. Your Lordships,
Anyway, let's go on. Yes, what else?
Lordships, I'll just make. Lordships, just have an item 61, page 158 for a moment. Lordships, just to show the mode and manner it was conducted, Your Lordships. Item 158 is the DME report. Your Lordships, have that?
We are not you. We first want you to tell us how you are getting over Vijender Singh. If it is your argument that you are getting over Vijender Singh only because in Vijender Singh he happened to have been given a show cause notice and the matter was this before an RME was constituted, we are not in agreement that that is a ground to distinguish.
But I will just differentiate the
To
judgment.
our view, Vijender Singh squarely covers it, and if not Vijender Singh, Priyanka squarely covers it.
Lordships, Priyanka,
Priyanka goes to the extent of saying even an outside hospital, a government hospital certificate will not be a basis to have a fresh medical.
Lordships, I'm just coming to that. Your Lordships, Priyanka actually will not be applicable on the facts of this case, and I will just come to that. Your Lordships, I'll try to differentiate. I'll leave it to Your Lordships, of course. Your Lordships, page 161 in this item 61. Your Lordships, the detailed medical board, the DME, Your Lordships, has given a tick mark on temporary unfit on the ground of anemia, saying that hemoglobin is 8.5. Your Lordships, just have 161 for a moment. Temporary unfit. Only anemia, nothing else, Your Lordships, this girl has. Yes, Your Lordships.
$161.
161, that's right, Your Lordships. Lordships, below in that Roman 3, temporary unfit. Is their medical examination that they had got conducted. I'm just trying to show the date.
Where are you reading this temporary unfit?
Lordships, 161, serial number 19, Your Lordships, Roman 3. Is a tick on temporary unfit low hemoglobin.
That is 162.
page numbers. I'm sorry, Your Lordships, I have been served.
You are now in item 79 or which item?
Item 61, Your Lordships, the first matter only.
Just a minute.
Yes, Your Lordships. One six.
Low HP, low
Hemoglobin, Your Lordship. Yes, Your Lordships.
Just a minute.
Yes, Your Lordships have it. It says low hemoglobin, 8.5 and temporary unfit. Now, if Your Lordships have this blood test was conducted at page 163, if Your Lordships have the report, they had sent her to Janta X-ray and it is of 21st of January. This blood test was conducted on that day, on basis of which the DME said she is temporarily unfit.
Just a minute.
Lordships, the RME in a gap of 5 days, Your Lordships, at page 167,
Yes.
gives her a permanent unfit certificate in Anemia. Lordships, my respectful submission here is an otherwise meritorious candidate qualifying, Your Lordships, just qualifying all stages. Your Lordships may be right in certain disorders, maybe not. But Your Lordships, in something like anemia, where the DME itself is of the opinion it is temporary unfit, and Your Lordships, that is why I coming back to those guidelines and coming back to Vijender Singh, which was so right in that case, that at least 1 month ought to be given. Your Lordships, we also know, Your Lordships, it is common knowledge, hemoglobin cannot just sort of increase in 5 days, Your Lordships. At least a month's time ought to have been given, and that is why those guidelines are relied upon.
Madam, anemia may be treated as a disqualification per se.
Lordships, that's what they said.
No. Wait a minute. Is there any guideline which says that if a candidate is temporarily unfit, he has a right to recruitment in a police service?
Lordships, that is why.
How do we know that a candidate who is temporarily unfit is ex facie disqualified? Where is this principle you are saying that all right? In the first medical report they say temporarily unfit. In the second medical report they say permanently unfit. Let's assume he is temporarily unfit.
Yes, sir.
Temporary unfitness may be good ground. He is unfit per se. A person who is suffering from low hemoglobin, he is in a police service. You see, that's why the Vijender Singh says, not Vijender Singh, any number. Preeti Yadav and all these decisions say that the principles are different when you are coming to police services.
Yes, Your Lordship.
The degree of laxity which is permitted in other services is not permitted in police services.
Yes, Your Lordship.
If a person is suffering from anemia, anemia can cause extreme tiredness. Now, suppose a policeman is on duty and his hemoglobin falls, it can create chaos. So, anemia, even if it is technically a temporary or a curable, it may not be tolerable in a police service.
Lordships, let me just put it this way, Your Lordships.
So, whether it is treated as temporarily unfit or permanently unfit,
Lordship,
he is unfit.
Lordship,
And on unfitness, there is concurrent finding both by the DME and by the RM.
Lordships, that is why to prevent that kind of arbitrariness, these guidelines have been
And if your argument is that you should give him 1 month so that 1 month so that in 1 month he'll have a lot of spinach and good iron and increase his hemoglobin, that's no argument.
Lordships, reasonable time is what I want to actually put across, not 1 month. Reasonable time. Your Lordships, Lordships, the guidelines I follow, Your Lordships cannot.
There is not a single guideline we have come across.
Lordships, this is the guideline that I read out. It says, Your Lordships, 1 month notice.
No, it says 1 month is the time within which he can
Appeal. Yes, Your Lordships.
Please, it does not say 1 month is the gap between DME and RME.
Lordships, had that been so,
He files an appeal. Now let us assume a situation where he files the appeal in 2 days.
yes, Your Lordships.
The authorities see the appeal. They feel yes, this requires a second examination. They have the RME next day. Within 3 days, they can have the RME.
Lordships,
It's not violative of the guideline.
Lordships, I am so grateful, Your Lordships.
Is that 1 month given to him to file an appeal?
I'm so grateful, Your Lordships. Your Lordships, just assuming, Your Lordships, for the sake of arguments in this case, what has come from Your Lordships is correct. But Your Lordships, in this case, that is why 2 government hospital reports, because once the DME says he's temporarily unfit, suppose 2 days later the candidate goes and gets their own blood test done, they know that what is the defect, it is a temporary temporary condition and it can be sort of cured. So they have that 1 month gap to whatever your lordships, medication, spinach, whatever your lordships, and then they have that 1 month's time, at least reasonable time to recover and go back. Things like pneumonia, things like anemia, your lordships, things which are recoverable. Lordships, and lordships, let me just say one more thing here, your lordships, since it's anemia and it's a girl over here. Lordships, even after delivery, most women are prone to low hemoglobin. Lordships, that doesn't mean it becomes something that permanently deters them from doing something.
Having all these, hypothetical assumptions.
It's not hypothetical.
We are dealing here, Mr. Counsel. I don't like it. When one counsel is arguing, we hear that counsel. I don't like cacophony either. So only I am entitled to make noise. So Ms. Majumdar, the point is, you can't start, titrating on these things. One, delivery may make a difference, or a person, there may be diseases which are temporary diseases which lower the hemoglobin. The moment you are out of it, COVID they said lowered hemoglobin. You get out of COVID, your hemoglobin will rise. See, it may be a temporary thing, but in a police service, if you have got anemia, it may be a disqualification. And if they have treated it as a disqualification, we are. Who are we to say that? You see, you are the RME has seen it and said 5 days back she was found with low hemoglobin. 5 days later also she was found with low hemoglobin. They are treating it as a permanent medical condition. Let's treat it temporary. It may be bad enough.
Lordships, just to I'll come to the next argument. I'll not trouble you, Lordships, with this one argument.
The point, Ms. Majumdar, is here we are considering a very limited point. The limited point is, did the court have the authority or jurisdiction in the face of the judgments passed by this court? Not one. Priyanka cites about 5 earlier decisions.
That's why I've gone through all of that.
Starting Preeti Yadav, something else. Then you have Vijender Singh, you have Amandeep Singh, any number of decisions.
Yes, sir.
We are not going, if you go to outside high courts, you'll have more. So the point is, when there are so many decisions, the tribunal have the authority or jurisdiction to mechanically say, have one more medical examination. See, it becomes a precedent for all time to come. That means to say, why one more, then why not 2 more? Suppose the next is bad, he'll come and say, well, I need 1 more. If you can relax 1, relax 2.
Lordship, that is why the predecessor bench said it has to be final and binding. We are not going to give any more opportunities whatsoever.
Who are we to say that if we can give 1 lakh, leeway, we can give 1 more? What's the problem? Where is this? If you can start relaxing without authority of law, then there is no reason. You can go on relaxing.
Lordship, I'll just make few more arguments. I'll leave it to Lordship. But just with this anemia point regarding that only, that had she had an opportunity after being told that she's temporarily unfit and had they followed their guidelines, she could have probably gone back in about 25 days, 26 days, and today the person would have a livelihood. That's my only argument with regard to temporary unfit.
That have a livelihood argument is
Lordship's clearing everything.
not that we are. We are sympathize all right. What can
Lordship, I know law may not be a
someone may have fever. Fever may be, he may be just having viral. Right, but if that viral is going on for 2 both the medical boards here, right now if they treat viral as he can't sit and appeal over it.
Lordship, I'll again answer that. That is why 1 month is the guideline. That is why.
No guideline.
Overcome
1 month.
Lordship, we just said that 1 month to appeal.
That's
1 month
of that guideline.
Lordship, 1 month to appeal.
That does not say that between DME and RME there should be 1 month.
Yes, they should not be, but the candidate has to file an appeal within a month.
No, candidate may, if he wants file an appeal, he has got 1 month. As I said, the candidate may file an appeal in 2 days, they may have an RME in 3 days. Where is the bar? There is no bar that saying no. Suppose he files an appeal in 2 days, you have to wait for 28 days more to have an RME. Where does the instruction say?
Well, Lordship, this argument, I leave it to that. Lordship, my next argument is that when these batch of matters came up before the tribunal, and one of the judgments that has been relied upon in Tika, Ram, etc., is Salman versus SSC and others. Lordship, Salman was a case by the same board which they constituted in that 1 week. Candidates were rejected on the ground of distance vision, color blindness, etc. For that, they complied with the tribunal's order. Lordship's meaning thereby, they themselves did not have confidence in their own medical board when cases of distance vision came. That's one. Secondly, Lordship's pick and choose could not have been applied. That for anemia, etc., we will not do a re-medical, but for distance vision, yes, our board may have gone wrong. We'll do a re-medical.
No. That's not the way it is. What has happened is, in that Salman's matter, there was a court order. Right? They complied with the court order. It doesn't mean that they have no confidence or anything. There is a court order, they complied with it.
Here also there's a court order, Your Lordship.
This order they have challenged. And if we find that the order is contrary to the law laid down by this court in umpteen decisions, we should uphold it and lay down a precedent that even after a remedical without any allegation of malafide, without any allegation of procedural infirmity, without a single allegation, except to say that I have got two other private medical reports or government medical reports which show that I am not suffering from it. We should ignore the law laid down by this court and allow this kind of a judgment to go unchallenged, untouched.
In Salman also, there was reliance on Vijender, etc.
Yes.
All of that was there. However, in that case also, the court was of the view that let us have an opportunity. Immediately in the month of June, they complied. Your Lordship, so that is my submission that it cannot be arbitrary so far as in the same medical board, Your Lordship. Same medical board. They say that for this particular ailment, yes, we will comply. For this ailment, we will not comply. And out of that, let me say this, Your Lordship, their confidence on their medical board, that two medical boards, so nothing can go wrong.
But Ms. Majumdar, that argument you can't say, because in fact I made a chart of what are the ailments. They have challenged in all cases. Now they may have complied in Salman, but here they have challenged in every case.
Lordship, Salman was not one person. It was about 150 candidates.
But, all right, but in that it was one judgment. They did not challenge. But here, starting from dental unfitness, low hemoglobin, high blood pressure, tonsillitis, distant vision, then knee, hemorrhoids, they have challenged for everything.
That's all I want to say.
So it's not that here now they are making any pick and choose.
No.
For all matters, they have come to the.
Except distance vision, Your Lordships. Except.
So even distance vision there is.
No, that must be distance vision and one more condition. It can't be only distance vision because there they have challenged, Your Lordships. I can say that. It must be distance vision and one more condition. Lordships, is it must be one of
Even squint.
Lordships, is it Ravina Mina Lordships are referring?
That too. Effective distance vision and stammering.
Yes, Your Lordships. That's what I'm saying. It can't be simplicity distance vision because there they have complied in all unilaterally. And Your Lordships, let me also put this to Your Lordships. Your Lordships, when they take such an arbitrary decision, but it may be good for some, where they complied with distance vision, there were 3 candidates rejected by the same board on color blindness who were found to be fit after the remedical pursuant to Honorable Tribunal's order.
But that is not a reason why we should. Suppose that you have 2 more medical boards, you will say the 4th medical board some candidate got cleared. Why not 3? Why should not it have more?
It is actually just an opportunity that has been given after they have produced government hospital reports. That's why the tribunal went into that.
This is not virgin territory. There are any number of judgments of this court. See, you may be able to. I mean, we don't see any way how you can get out of all these decisions.
Lordships, then I'll come to Lordships. I told you on the last day.
Also,
fine.
he says the same thing.
Lordships, Priyanka, now Lordships, just coming to all the judgments that they've relied upon, I'll differentiate Priyanka. Lordships, barring Vijender Singh, every other judgment is for either BSF, CRPF. Your Lordships are aware the nature of duties is very different. Lordships, the Delhi Police Act, I think Section 3, it provides that it is only to protect the Union Territory of Delhi. Other than that, the CRPF Act, the ITBP Act, the BSF Act, it is for borders. That is why KM Priyanka in every other judgment except Vijender.
Para 8 in Priyanka says we have on several occasions observed that the standard of physical fitness for armed forces and police forces
Yes, Your Lordship.
more stringent than for civilian employment. So even if on facts
ITBP.
dealing with armed forces, they have made the same. They say this will apply to armed forces and police forces.
Lordships, now we'll just.
So once the division bench has said that, it applies.
Lordships, police forces can also mean border police, that is ITBP, Indo-Tibetan Border Police. No, Your Lordships, I'm sorry, Your Lordships, I'm saying this for relief again. Lordships, there's a reason I'm saying this, Lordships. Why I'm making this submission is, except Vijender Singh, in all the judgments that they've filed, I've not come across even one out of those 40 judgments they've filed where it is regarding Delhi Police. Vijender Singh is the only one.
Now you'll have one court.
Lordships, okay.
Are we going to make this distinction? Police force can be involved in during the time of the 1984 riots. What was the police force doing here? When people's houses were burning, The police had to be there. Now, suppose someone suddenly has a anemia attack, when he has to go and save the person in the house. See, the point is, you see, ultimately the point is that these are all forces, whether it's police or it's armed forces, they are basically protect the security of people. The public is at their mercy. So, their standards have to be higher. I mean, how do we justify this? Forget the fact that these orders per se are bad, because the learned tribunal has just got and copy pasted on full para without any application of mind. In most cases, many cases, we don't even find what is the ailment which they are suffering from, and they've just said that this they are following this. We are directing a fresh medical. There's no way to write a judgment. But apart from that, even if you go into all these aspects you are saying, we are treating, forget about the tribunal judgment. We don't find how we can allow a fresh medical examination in the light of Vijender saying.
I will just make an attempt, Your Lordships, to distinguish those judgments. Another point, another argument that I want to raise is there was no specialist on the board, in the medical board or the review medical board. I've prepared a chart. I can actually, in my matters only, of course, Your Lordships, I can pass that on. They have in fact filed their details of the doctors who were there. There was a CMO, there were 2 GDMOs, that is it. So, Your Lordships, an ophthalmologist checking a person who has some skin infection, Your Lordships, then this is bound to happen. Your Lordships, besides that, that is one part of it.
A normal general physician can do it.
Your Lordships, that is what I want to say. KM Priyanka and all the other judgments which Your Lordships are rightly referring to, all those cases, Your Lordships, there is a specific mention that the specialist has examined. Out of those 40 judgments, there are about 10 judgments where the court had in fact called the specialist or asked for a written opinion for subjective satisfaction that why this condition leads to unfitness. I'll rely on those judgments also. Your Lordships, I'll come to differentiate that. So, Lordships, even KM Priyanka, in fact, if Your Lordships have KM Priyanka right now, Lordships, para 8. Para 8, Your Lordships, I think it's Lordships, I'm just coming to that. Lordships, I'll just read this out. It says, para 8, in KM Priyanka. We have on several occasions observed that the standard of physical fitness for the armed forces and the police forces is more stringent than for civilian employment. We have in so and so, held that once no malapitates are aptitude and the doctors of the forces who are well aware of the demands of duties of the forces in the terrain in which the recruited personnel are required to work would form an opinion that a candidate is not medically fit for recruitment. Opinion of private or the government doctors to the contrary cannot be accepted in as much as the recruited personnel are required to work for the forces, not for private doctors or government hospitals, and which medical professionals are unaware of the demands. Lordships, it is also to be noted that the specialists that the petitioner had consulted had also, Lordships, I'm sorry, there is a averment with regard to these specialists being on the board. Lordships, I'll just give that. Lordships, I'll just give that. There is an averment with regard to specialists being on the board. I'm sorry, Your Lordships, I think.
Not in Priyanka.
Lordships, no, there is.
Priyanka is just a 2-page judgment. We don't find anything to say special. She went to a specialist.
Lordships, she went
to a specialist and got a separate opinion.
And Your Lordships, there was, Lordships, the procedure that has been followed in KM Priyanka in this particular case, Your Lordships, is at para 2. I will read that. It says, the petitioner appeared for the written test on 14th February 19 and qualified the written test. Subsequently, she appeared for the physical standard test, physical efficiency test, was also successful in this. She was called for medical examination. Unfortunately, was declared unfit for carrying angle. She was issued a medical unfitness certificate on the same day, that is 20th January. She was granted a chance to file an appeal against the findings. Before filing the appeal, she was also required to obtain a medical certificate from a medical practitioner or specialist medical officer of a government district hospital. Petitioner approached the specialist orthopedic surgeon in the Boring and Lady Curzon Hospital, Government of Karnataka, who, after conducting a thorough examination, declared her fit. On 26th October, petitioner appeared before the review medical board, which again found her unfit for the same reason. She questions this conclusion. So, Lordships, this is the procedure which has been laid down in all the armed forces, that the person has to be given an opportunity to get medical certificates and thereafter apply for a remedical examination. That procedural deviation, Your Lordships have been asking what is the deviation. Lordships, that is the procedural deviation.
What is the deviation? We were asking was because even if she provides a certificate from a specialist from the outside hospital, the consequence is not that she can have a right to be considered on the basis of that opinion. Suppose the instruction were to say that we have a medical board, you produce a specialist opinion, they will be bound by the specialist opinion. Then I can understand. They say no, if you produce a specialist opinion, they may take a view that alright, on the basis of this, a review medical board is necessary.
Yes.
That's the highest she could have got.
Yes.
A candidate can get by producing a specialist opinion. Now here she has got that. So once they have got that, and then how does it make a difference whether in that interregnum a specialist medical board opinion was obtained or not obtained when it is not conclusive of the in any way?
Yes, Lordship. Lordship, so just to answer the question with regarding to specialists for this reason, had they been given an opportunity to get 2 certificates? So, Lordships, ideally it would have been the RME considering of general duty medical officers against the opinion of a specialist. So at least they would have got a specialist on board to consider and compare. Lordships, for example, for cubitus valgus, that is the carrying angle of the hand, you need an orthopedist.
Miss Majumdar, if it is your argument that the medical board was improperly constituted, you show us, number one, that you have taken that argument in the CAT. Number two, you will have to show us that these are the guidelines or these are the instructions which say that these are to be the persons who are on the medical board. This is the constitution of the medical board. It does not conform to that. Make out that case if you want to argue that.
Lordships, I'll just show one.
Not just generally there should be a specialist.
Lordships,
Today, I can name a doctor in Delhi who is a general physician who is better than any specialist you can think of.
hemorrhoids, etc., has to be seen by surgeon. I mean, your Lordships are right. There may be some exceptional. Lordship, there are people who are extremely intelligent in every profession, but there may be mediocre doctors who may be sitting in the board. That is why you need a specialist. Lordships,
we cannot be starting to decide these things.
Lordships, these judgments everywhere there are specialists. There is a requirement of a specialist in it.
Show us that there is some either that there is a judicial pronouncement saying a specialist mandatorily has to be there,
Lordships,
or you show us that there were no specialists. These are the guidelines. This is the law. Specialist not being there makes it invalid. And you will have to also show us that this case was taken before the tribunal.
Lordships,
Make out a new case here.
Lordships, I won't. Lordships,
The tribunal anyway hasn't gone by that. We are giving you the liberty to show us that this argument works.
I'm so grateful. Your Lordships, Lordships, in this case, the Lordships, I have the standing order, which is at page number 55. Standing order of Delhi Police. That relevant portion, relevant pages is page 75, your Lordships. Standing order starts at 65. Lordships, just to fortify my argument.
55 of item 61.
61, your Lordships. I'm only trying to show 60 now.
No, item 61.
61.
65.
65 is the standing order of Delhi Police, which they have filed along with their writ. They rely on these guidelines. Yes, ma'am. Clearly showing in view of the judgments that they are relying upon KM Priyanka and Vijender, where it is said that government hospital, private hospital report should not be considered. Their own standing order. Now, if you Lordships have para 26 at page 76, which is the running page number, PDF page numbers I'm not able to say.
Para 26.
Para 26. In their standing order, this is what is mentioned, your Lordships. Medical examination. Lordships have it. The candidates so selected shall get themselves examined by the medical officer in any central or state government hospitals as per prescribed standards. So, Lordships, that is what we've done. We went.
Candidate selected.
Lordships, yes, they're selected. Their names are there in the final result, 24th of January 24. Lordships, in fact, Delhi Police has issued the result this time before the medical, and all of them are qualified who are before your Lordships today. So, Lordships, they themselves give the liberty that yes,
Clause 26 of
20 standing.
Yes, clause 26.
Lordships, standing order number HRD 4 of 22 of Delhi Police. They have filed with the
4 of 22.
4 of 22. Lordships, Lordships, it's just 4 of 22. Lordship, there's no page number at page 55. Sorry, there's no. Sorry, Lordship, there's no date on the standing order. They'll be able to say if there is because they filed it.
All right. You say yes.
Lordship, lying on this, Lordship.
All right.
Now, if your Lordship had put to me that where is it written that there was no specialist and just show us how was the composition. Now, if your Lordships have page 156 of the same matter, your Lordships.
No, before you show us that, you will have to show us that there was a requirement of a specialist.
Yes, your Lordships.
Where is this requirement?
Lordships have prepared a chart with regard to ailments. Your Lordships, for the specific ailments, your Lordships, such as cubitus valgus, I say anemia, etc., anyone can examine. We don't need any pathologist for that, there's no dispute. Lordships, for things like hemorrhoids, for things, 2 GDMOs and 2 eye specialists, one each for RME to be arranged and detailed by Delhi Police. Lordships, despite having an eye specialist, that is the only order they complied with. They did not have any other surgeon. This is something that I just saw, that they needed an eye specialist on each wood, but they did not have a specialist for any other ailment. Lordships, just to show the constitution of the board to your Lordships. Now, your Lordships.
Now, do you have anything to show that this constitution is violative either of any law laid down in a judgment or any law laid down in any statutory or executive decision which says that this constitution is violative? Because if it is not, Ms. Majumdar, let's be very fair, very frank, we can't sit and say that according to us you need a specialist.
Your Lordship, so my friend says
that goes beyond our...
Lordship, my friend says there's a division bench judgment which says there has to be a specialist on board.
Wait, if there is something.
Lordship, by then I'll just take out my compilation. I've filed a lot of judgments. Your Lordship is saying judgments on the other side, so we brought them on record. Our compilation we had filed in item number buttons in these Lordships we had filed.
Now is some other matter now you want.
Lordships, actually, every time the list would come, some other matter would be on top. So we would try to file, but then it would again come down. So, Lordships, item 78. I have filed my compilation in that, your Lordships.
78.
70. Item 70. That's right.
Yes.
Lordships, I'll just read that out, but by then maybe my friend can.
What are you reading?
Lordships, certain judgments. Lordships, there are judgments where. Lordships, Rajneesh Kumar, no, your Lordships.
No. There is one compile. There are two compilations here.
No, Oh, yes.
One is of 1st of October, one is of 11th of October.
Your Lordships, 1st October, because your Lordships had said to bring that Deepak Salman, etc. on record.
Yes, are you
Lordships, the 11th, subsequent.
Just a minute. Yes.
Your Lordships, I will just go through these judgments. Your Lordships, by then my friend can arrange that one that says specialist is required. Lordships, the first judgment, in fact, Dharamveer, I had read out on that day. That's a Supreme Court judgment in a writ petition, but that I've annexed. But your Lordships were of the view that under Article 32 they could have done. We will not do it under 226. However, Lordships, this was another condition where the person had some nasal issue, got himself operated. He got himself operated by 2 medical boards. He was rejected. Thereafter, he got himself operated. And the Honorable Court at page 2, your Lordships. If your Lordships have page 2. Yes. Lordships, it says at about 5th para from the top, 3rd para, from the top. It is true that the petitioner was examined twice over and was found to be medically unfit. However, considering the nature of ailment and medical condition,
आपने इतनी लंबी बहस में आशा और विश्वास करता हूँ आपने पूरी सुनी होगी और आपको हंसी भी आ रही होगी, आपका दिमाग भी ख़राब हो रहा होगा और आपके मन में भी सवाल उठ रहा होगा कि साला अगर मैं वहाँ पे होता तो मैं ये बोलता है सब ख़त्म कर देता। लेकिन ऐसा कुछ है नहीं, ठीक है। वहाँ पे खड़े रह के बात करना इतनी देर तक, देखिए मैंने पूरी बहस रिकॉर्ड करना तो काफ़ी मुश्किल था, लेकिन आधे घंटे से ऊपर का मैंने बहस रिकॉर्ड कर लिया है और आधे घंटे से 5 मिनट के बहस से पता चल जाता है कि मूड क्या है। ये तो मैंने आधे घंटे का बहस रिकॉर्ड किया है, क्योंकि काफ़ी लंबी तक बहस चली थी, तो वो मैं रिकॉर्ड नहीं कर पाया। लेकिन मैंने ये सोचा कि ये आधे घंटे तक का ये रिकॉर्ड करके आप तक पहुँचाया जाए, और फाइनल जो रिजल्ट आज क्या निकला है वो मैं लास्ट मेरे ज़रिए में बता दूंगा। तो फाइनल ये रिजल्ट निकला है कि कल नहीं परसों 2:30 बजे से 4 बजे तक फिर से बहस होगी, और परसों डिसाइड हो जाएगा कि कौन से पॉइंट अलाउ है कौन से नहीं। देखिए, टैटू वाले का कोई भी इश्यू नहीं आने वाला है, टैटू वाले सारे अलाउ हो जाएंगे, क्योंकि 15 मीटर अलाउ हुए हैं, 2 से 3 मीटर अलाउ नहीं हुए। उनका भी रीज़न ये है कि ग्राउंड तैयार, देखिए जो सस्ते वकील के चक्कर में थे, या फिर ऐसा था कि नहीं, पहले केट का एक अलग मामला था, केट के अंदर पहले दिन गए, दूसरे दिन को जीत गए, लेकिन उसके अंदर जज अभी ये देख रहा है कि आपने ग्राउंड कितने लिए, क्या ग्राउंड आपने तैयार किया, बस उसी के ऊपर अड़े हुए हैं जज साहब। इसलिए अभी टैटू के भी अभी कल का टाइम दिया है, परसों 2:30 बजे से 4 बजे फिर से वैसे, लेकिन बीपी वालों को दिक्कत आ सकती है। ये जो पॉइंट है एनीमिया, मतलब 2-3 पॉइंटों के अंदर दिक्कत आ सकती है, लेकिन जो जैसे स्कोलियोसिस, जो ऐसे पॉइंट है जिसके 1-2 कैंडिडेट है और जो पहली बार ऐसे देखने को मिला, उनमें कोई भी दिक्कत नहीं आने वाली है। उनके मैं ऐसा विश्वास आपको दिलाता हूँ कि पहली बात तो केट के ऑर्डर से ही उनके रीमेडिकल हो जाएंगे, अगर उनके नहीं होंगे तो हाई कोर्ट के अंदर जाने पहले हेयरिंग के अंदर ही काम हो जाएगा। उनके अंदर इतनी बहस नहीं होने वाली है, टैटू के अंदर भी इतनी बहस नहीं होने वाली है, उनके भी हो जाएंगे, ये विश्वास आपको दिलाता हूँ मैं। लेकिन बीपी का पॉइंट हो गया, 1-2 पॉइंटों के अंदर दिक्कत आएगी, उनके अंदर बहस चलेगी, आपका ग्राउंड देखा जाएगा, कितने ग्राउंड लिए गए, आप अपने जजमेंट देखना, केट के ऑर्डर के अपलोड हुआ है वो देखना, उसके अंदर क्या कुछ ग्राउंड लिया गया है, उसके ऊपर टिकेगी। लेकिन कल का आपको वेट करना पड़ेगा, परसों वापस 2:30 बजे से 4 बजे के बीच बहस रहेगी, उसके अंदर क्या कुछ रहेगा, कितने पॉइंट अलाउ हुए हैं, क्या कुछ है, वो नेक्स्ट वीडियो के अंदर आपको बता दूंगा। इस वीडियो के अंदर आपने अच्छे से सुन लिया होगा बहस ईसा मैडम की, और एक बार धन्यवाद बोलना ईसा मैडम को कॉमेंट बॉक्स के माध्यम से, ठीक है। आशा और विश्वास करता हूँ कि आज कुछ भी नहीं हुआ, नेक्स्ट तारीख मिली है, आज सिर्फ बहस हुई है, और आधे घंटे की बहस मैंने रिकॉर्ड करने की कोशिश की है। आशा करता हूँ आपको बहस जो रिकॉर्ड की है उससे आपको बहुत जानकारी मिलेगी, आपको सब पता चल गया होगा, आपको सारे डाउट क्लियर होंगे। आप शायद अब नहीं पूछोगे कि सर कब होगा मेडिकल, कब होगा मेडिकल। आपके हाई कोर्ट का जो जज साहब है हरिशंकर, उसका आपको पता चल गया होगा कि जज साहब कैसे मन के हैं, कैसे सोच के हैं। तो चलिए मैं बिना टाइम वेस्ट के वीडियो को यहीं करता हूँ, नेक्स्ट वीडियो में नेक्स्ट जानकारी में मिलते हैं। कल नहीं परसों का आप इंतजार कीजिएगा, परसों भी वीडियो अपलोड करूँगा, क्या कुछ रहा पूरी जानकारी देने की कोशिश करूँगा। चलिए, जय हिंद, जय भारत।